Anyway, so being the first lawyer, legal scholar to speak today, and I know that the audience is mostly...
Arie.
Both you and Sharon are lawyers, but you're not legal scholars anymore.
Okay, let's not waste time on this interview.
Luckily.
אני בבין תחומי.
Into this, okay. No, I did it first, they said to me. Anyways, I'll try to address myself also to people with international relations background. So we all know that the EU has an interest in exporting its acquis communautaire, its laws and regulations and so on. But another thing that lawyers know is that it's not enough to take legislation and to translate it, copy it into the law books of other countries outside the EU, but it's also very important how these laws are being interpreted. And interpretation is something that is done by courts and other authorities, and the authoritative interpreter of EU acquis is the European Court of Justice. So this project that I'm engaged in wants to try to understand to what extent the ECJ, the European Court of Justice, is also a player in this exportation of EU law to countries outside the EU. To what extent does the ECJ have an external impact outside the border of the ECJ? How much is it cited? How much does it have influence on the laws in other countries? So, and if we do find such impact, in what fields does the CJEU, like they call it today, I'll say ECG for J, in what field does it have impact and what extent of an impact does it have? And also to try to understand what are the causes. As you'll see, we'll find in some countries there is, in some countries there's much less. What are the powers in play here that cause it to be have an impact? Why do some judges cite and rely on the ECJ and others don't? So this is a project, a group project, a group of researchers that I recruited from different countries outside the EU. I'm doing it together with my partner, Professor Hans Miklitz from the European University Institute in Florence. And we recruited legal scholars from different countries, like you see here the list, outside the EU, both in Eastern Europe, former Soviet Union countries, Middle Eastern countries, North Africa, Switzerland, and we also have an international organization, which is the European Asian Union, which also has its own court, which is also interesting to compare. We'll get to that.
One from Jordan.
Also Georgia, yes.
Jordan,
yes, Jordan. Yeah. So we have Jordan, Tunisia, and Turkey, if you're talking about Muslim countries. We also will have a contribution by Judge Professor Alan Rosas, who is a judge on the European Court of Justice, a Finnish judge. Now, we know that in many of the agreements that the EU make with non-EU countries, the so-called Europe agreements, association agreements, and what have you, there is often a clause, a provision dealing with issues of harmonization of law. Some of them are weak, like in the Israeli agreement, association agreement. Some of them are much more mandatory, much harder, make it much more clear that it's the other country that is supposed to adopt EU acquis, etc. For instance, the Georgia-EU association agreement, very strong, very clear obligations set to put it very clearly what they have to do. So we would expect to find some correlation between the amount of citation that we have of the ECJ in countries with a strong harmonization clause as opposed to those with a soft one. Actually, we didn't find that. There is no such correlation at all, which is an interesting finding. So you saw the list of countries, and looking now back on the whole project, I just came back on Sunday from Florence after hearing final papers of my co-researchers. I'm able to kind of very very broadly divide these 12 countries into 3 groups. The first group is one where we find a strong impact of the ECJ. One is, this group includes Switzerland, Ukraine, and Turkey. Not that they're similar, there are many differences between them, but in terms of the amount that we found, they are together. If I have more time, I can go into the nuances between them. But I'll show a little bit more. For instance, in relation to Switzerland, Professor Francesco Maiani, who did this paper, he explains that there is 2 different types of citations that we will find of the ECJ. One is mandated. In other words, where Switzerland has taken upon itself an obligation not just to harmonize its laws, but also to harmonize its interpretation of the laws with the interpretation given in the EU, in other words, by the ECJ. This applies to, for instance, the Air Transport Agreement, Free Movement of Persons Agreement. The Lugano Agreement is about private international law, Land Trust Transport Agreement. But what's interesting, there is also a unilateral, autonomous application of the ECJ case law, which is spontaneous. In other words, the Swiss court has decided that this is the right thing to do because otherwise they won't achieve uniformity. And as a result, he found several thousands of ECJ citations in federal Swiss judgments, mainly since 1997. We decided together that he's going to limit himself only to federal courts, because if you go into the cantonal courts, there will be just tens of thousands of decisions, something that is unable to go through and to assess. So, for instance, here is a quote from the Swiss Federal Supreme Court in relation to this spontaneous application. They say domestic law that has been autonomously adapted to EU law, even if they did it without an obligation to do so, must in doubt be interpreted in a Euro-compatible manner. When the Swiss legal order is adapted to a foreign legal order, here is EU law, harmonization must not be sought only in the formulation of the norm, but also in its interpretation and application, insofar as this is permitted by the method of interpretation that must be observed in national law. In other words, if it contradicts the Swiss constitution or something like that, obviously they won't go that way. But unless there is a very strong reason not to do so, this is what the Supreme Court is basically telling the lower courts that they must do. The interpreter must not only consider the legal situation known to the legislator, but also keep an eye on the subsequent development of the law with which harmonization is sought. So it's not just the way the law was when an agreement was made between Switzerland and EU to harmonize, but it's also a dynamic process. They have to look if there's an innovation in EU law, the Swiss courts have to keep pace with this. So this is a very deep type of impact that the ECJ has, sometimes without knowing it. Coming to Turkey, indeed there are, in addition to the regular provision on harmonization of law, there is a decision under the association agreement between Turkey and EU that also case law needs to be followed in certain areas. The provision of this decision is so far as they are identical in substance to the corresponding provisions of the treaty establishing the European Community. For instance, that applies, for instance, to competition law, certain fields of immigration law, shall be interpreted for the purpose of their implementation, application to products covered by the customs union in conformity with the relevant decisions of the Court of Justice of the European Community. And indeed, the number of decisions that were found in Turkish courts in the last 10 years, you have here before you. The first number is the number of cases. The number in parentheses is the number of ECJ cases cited in those. So you can have one judgment by a Turkish court that cites several different ECJ decisions. Those are in the parentheses. In what field? mainly in labor law and IP. The fact that you don't find it in constitutional court, that means that the Turkish constitution doesn't think that it has to follow ECJ in constitutional matters, more so maybe in the European Court of Human Rights. But I would say that considering the deep integration between that Turkey and EU are trying to achieve, or at least were trying to achieve, and this decision that I cited before, I would expect even more than that. And in fact, we see a decline in the last few years in the numbers of citation, which is not very surprising given the current political climate in EU and in Turkey under Erdogan.
And the legal climate.
And the legal climate, yeah. Those judges who used to cite, they might be in prison now.
Or in the Saudi embassy.
So in the Ukraine, turning now to Ukraine, this was a paper done by Professor Roman Petrov from Kyiv University. These are the numbers. Actually, they're staggering numbers. 118,000, or even almost 119,000 decisions by the ECJ that were cited by regular common courts in the Ukraine. However, it looks more than it is. After having done some more qualitative examination of these cases, they're in a very specific fields. Many of them have to do with the Chernobyl catastrophe, and where one court wrote a decision and based on that accepted damages claimed by victims of the Chernobyl catastrophe. All of a sudden the government stopped paying them the money that they were supposed to. So they all, thousands of them came to court. And basically it seems like all the judges just cited the first decision by the first court, not that they knew how to read ECJ decisions. There's in many of these countries a serious problem of language and of access, which has also gives us some idea of of policy recommendations regarding what you should do if you want there to be more impact, such as translating these decisions to Ukraine language or Russian language, etc. Countries with very little impacts, and I go to the lower group, are Jordan, Tunisia, Azerbaijan, Belarus, Armenia, and Brazil. We also had a country from South America. Every researcher was asked, why so little? Okay, you almost found no impact. Why is it? So many of them pointed to language barriers, cultural barriers, the type of judicial education that the judges are getting, and this also is a basis for policy recommendations. Countries in the middle, which I call countries with modest impact, include Israel, Russia, and Georgia, as well as the court of the Eurasian Economic Union, which includes four former Soviet Union countries: Russia, Kyrgyzstan, I think Kazakhstan, and Azerbaijan, I think, if I remember correctly. And this is interesting because this whole union was kind of modeled after, to a certain extent, after the EU, and it also established a court of this Eurasian Union. It's supposed to be kind of an alternative to EU. Don't join the EU, stay with us, kind of thing. But this court, it's natural for it to turn to the ECJ because they're doing the similar thing that we're doing, free movement of goods and things like that. So it's a natural path to turn to the ECJ. It's a very young institution. This one exists 2 years. The previous one, they had a change. It was called Community. Then another 2 years. So altogether, it's only 4 years. So there could be, relative to the time that they're around, there is an impact. So in Israel, coming now to Israel, this is a session on Israel. So in Israel, although we do have a harmonization clause in our agreement, it's very weak, and I'm willing to make a bet with anyone who wants that none of the judges in court know that it exists. So what I'm trying to say is that if they do cite the ECJ, they don't do it out of any sense of obligation. Rather, they turn to it as comparative law. And Barak once said in one of the decisions, comparative law is like an experienced friend. It's good to listen to his good advice, but it should not replace one's own discretion. This is the way they turn to ECJ and other courts, American courts, Canadian courts, not as in a sense of obligation, but rather to hear what the other courts have to say. So this is the table that shows my findings regarding Israel. I wrote the paper on Israel. Altogether, I found 105 decisions in these various tribunals that have something like 246 different ECJ decisions or holdings. You can see that most one are in the Supreme Court, but also something that I expected a lot in a competition, it's an antitrust tribunal, and indeed there are. But also, what was interesting, that a lot of trademark decisions. How much time do you have?
You're up, but go ahead and do another minute.
A lot of decisions in the field of trademarks cite the ECJ. I spoke to some of the registers. They told me, yeah, because we often get companies who want to register a trademark. They're international companies, Nike, Coke, whatever. And you have to make sure that your interpretation of what they can do, what they can't do, if you do recognize a trademark and so on, it has to be in line with what's being done in the big jurisdiction. So that would be the US and the EU. That's why we follow very closely what these courts do, and we try to harmonize our decisions with theirs. So I'll just jump to the very end. Oops. Okay. You just see this one. You can see that the number of citations in Israel is on its way up. And I've also done an assessment of not just of the numbers, but also what was the impact of each citation on the decision. Because you can have something, they cite a decision and say, yeah, but I disagree with it. Then there's no impact. Or you can see that they cited it, but it didn't seem to be something that actually had an impact. So I have done like an assessment of all of those 105 decisions to see what the extent of the impact was, and you can see that there are several that had strong, very strong impact, significant impact. By the way, I did, if you want to read the full paper, it was just uploaded on SSRN 2 days ago. If you look under my name, you'll find the full article. So just going to the final conclusions, which are as follows, that we do find impact. It's a limited impact. I don't want to overemphasize it. If you compare it to the citation of English courts or American court, it's still much less. But remember that the ECJ is a new court. In the first years, it wasn't involved in issues that have to do with Israel. So EU regulation has much more impact than ECJ case law. However, the impact is growing over the years, and there may also be invisible impact that we don't find in actual citations. Thank you very much.